Welcome, everyone. I'm Leslie Orloff, and I direct the National Immigrant Women's Advocacy Project at American University Washington College of Law. Thank you, NCJFCJ, for hosting us. And I will just take this second to welcome everyone and to thank OVW for their support for this webinar. The opinions you hear today will be us, the speakers, and not OVW. So I'm particularly happy to be here today because I was actually, I'm old enough to say that I was involved in drafting the Battered Spouse Waiver and getting it, working with Congress to pass it in 1990, and then worked, as many of you may know, on the Violence Against Women Act as well. And one of the reasons I'm excited about this webinar in particular is that it is really this interesting blend. We're going to be talking today not only about the immigration provisions and how they work, and we're going to be sharing with you some information that came from a Freedom of Information Act request on battered spouse waivers that NUAP did several years ago, a couple of years ago, but also because there are some pretty interesting and significant family law implications that we're going to be discussing about what this means for family lawyers and judges, and what kind of waiver a battered immigrant seeks of the, and Veronica, as our immigration expert, will be talking about this more, could have some pretty significant public benefits impacts that we're also going to be talking about. So as we get started, just, you know, and also, so on this call, you have essentially 3 expert family lawyers, 2 immigration lawyers, and a fabulous judge. And so, Rosia, I'm going to have you introduce yourself first because she's going to be helping us answer your questions in the chat. Rosia?
Yeah. Hi, everybody. Welcome. Great to say hello and see everyone from everywhere. I'll be answering your questions on the chat. You could use the chat function or you could just use the question and answer. I'll be monitoring them both. There'll be some questions that maybe we will decide to stop and cover while the presenters are presenting, and there's some that we might hold till the end, and then there's going to be some that we're going to just get back to you with a document with all the Q&A put together so you can all review. So we look forward to interacting with you and learning about this subject.
Veronica.
Thank you. Good afternoon, everyone. Veronica Stronson. I'm a clinical professor with the Michigan State University College of Law, where I direct the immigration law clinic. Prior to this job, I was directing attorney of a domestic violence project at Legal Aid in Las Vegas. So hopefully we have people from Las Vegas joining us as well. And as part of my academic career here at MSU, I also teach a domestic violence law elective to upper level law students. Thank you.
Judge Collins.
Hi, everybody. I'm retired Judge Collins. I'm from Northern Illinois, the 17th Circuit, and I was on the bench for about 30 years before I finally retired. When I was on the bench, I was the presiding judge of the family division. I was also the presiding judge of our domestic violence division. I established a coordinated domestic violence court where we combined both criminal and civil cases in the same division, although they were heard by different judges. So I spent a large part of my career doing family and domestic violence cases. I also did a criminal caseload. We were a mentor court for the Department of Justice because of our innovative practices with domestic violence work. And what I'm going to talk to you about today really is what implications for family court this material has. What are best practices for courts, what you can do if you're a practicing attorney, what to get included in your order, and how to navigate through the court system with this information. So it's great to be here with you all today. So now, after we've introduced ourselves, what we'd like to do is hear a little bit about you. So if you could check the box that best describes you, we'd love to hear that.
There should be a poll box coming up on your screen.
Yep.
We're going to give you a few seconds to respond. I'll leave the judge in charge of that.
All right. I see we have a large amount of victim advocate and coalition staff, about over 50%. We have about 17% family law attorneys, judges. We have a small, and court staff, we have a small percentage for that. And then we have more prosecutors, law enforcement, and victim witness staff, and then other. That I hope you'll put in chat what the other is so that we can see who you are, like immigration paralegal. I got that. So yeah, it's a great broad range of people here today. So I think we'll have a lot of good questions from you, and please feel free to type in your questions. We want to make this as relevant to you as we possibly can. So thanks.
Okay, so. Okay, there we go. So where we're going to start is we're going to go over some of the legislative history of the battered spouse waiver provision, why it was created, what we were trying to accomplish, so that you guys can better understand kind of what the purpose of this is, and hopefully we'll understand how this fits in with VAWA self-petitions and U visas and the things that many of you may be more familiar with.
So now we'd like you to check all the boxes that apply. Have you worked with an immigrant survivor who had a green card, told you the divorce would lead to losing their legal immigration status, was afraid to separate from their spouse because they thought they needed his signature, or whose abusive citizen spouse had filed immigration papers for the victim? So let us know. You can check all that apply. So we have a lot of results coming in. Good. Thank you for participating. All right. So it looks like we have the biggest percentage of responses are to the one that was afraid to separate from their spouse, but very close. It's told you that divorce would lead to losing their immigration status. And then after that was abusive citizen spouse had filed immigration papers for the victim, and then worked with the immigrant survivor. So a wide range of experience here. Thank you.
Veronica, what are you seeing? How does that match up with what's in the field or what you've experienced? You're on mute.
Basically, very similar to what I see in my practice here in Michigan and what I used to see as well, right? Like many times people are getting the wrong information. And so it is important for people to see that there is relief for victims, right? In your interaction, you know, you really don't need to be an immigration attorney to know this stuff, right? That is the point of having this webinar. So you get that information in case you encounter someone who may have the wrong information about the process, and then you are able to guide them. So let's talk about the conditional permanent residence. One of the things that is important to know is that back in 1986, Congress passed the Immigration Marriage Fraud Act to prevent people who were married to a US citizen or a lawful permanent resident, someone who had a green card, who had been married for less than 2 years. The green card that they were going to be receiving was going to be conditional to make sure that they were checking to prevent people from committing marriage fraud. So that's one of the reasons why it is important to talk about the conditional permanent residence. So as they are applying to become lawful permanent residents themselves, if the marriage is of short duration, then the green card they are going to receive is going to be conditional. At the end of those 2 years of the condition on the green card, then they are able to file to remove the conditions on that green card to get a permanent 10-year one. And the petition is called a joint petition. So you are expected to be filing this joint petition with your US citizen or lawful permanent resident spouse. So it is important to notice too that the conditional green card doesn't apply if the immigrant has been married for 2 years or more. And one of the examples would be if someone is married to a lawful permanent resident, because there is they have to have a visa available to them, and many times it takes years for someone to finally reunite with their spouse, who may be only a lawful permanent resident. So for those marriages, it's going to be past the 2 years. So that's important to think, right? Like usually immigrants who are married to a US citizen don't have to wait for the process because there are always visas available to immediate relatives of US citizens. So we are going to be seeing more of the conditional green cards with people who are married to US citizens.
And if I can add, one of the ways I like to think about it is when Veronica was talking about the Marriage Fraud Act in 86, basically that changed all of immigration law to presume that every marriage is fraudulent and everybody has to prove to the Department of Homeland Security that it's a legitimate marriage. So they created this 2-year period. So if at the time you're ready to get your green card, you've been married less than 2 years, and which will be, as Veronica said, basically the cases of spouses of citizens, because the other ones are still in line beyond 2 years, then people are told they have to show up together to prove it's still legitimate. And that's why people have the assumptions and tell courts that they're trapped in these relationships and can't get a divorce and things like that. And we're going to explain how they can, and that we created this battered spouse waiver so that they wouldn't be trapped in these relationships.
So let's talk about now, how do you think family courts might play a role in this?
You can feel free to type in the chat.
Yeah. So how might family courts, I mean, why should we even consider what family court's role is in this? So anybody got any ideas? Just see if I can put in the chat. Oh, and I can tell you that somebody wrote in, can we comment on common law marriage? And we will be doing that. So one of the things that family law can do is try to identify these cases when they come into the courts. And why might that be of interest to the courts? Well, sometimes you'll have people trying to delay the proceedings. Sometimes you'll have people trying to speed up the proceedings, and their purpose for that might be totally involved with the immigration aspects involved with their partner's case. If you look at cases that are in the court system, you have an immigrant spouse, then you should always look at what's the party's stance in the courtroom about either trying to slow it down or speed it up. And it also has implications for family courts, because what do we do every day in almost every case? Well, we make a decision and we enter findings. And it's really important that you get your state court judge to be clear and complete and make orders that really reflect all that led to the findings, because that information is really important for the surviving spouse when she has to go and get her paperwork approved. So the more information you can have in your court order, and the more grounds for it, for your decision, the better off you are. Any other reasons that Leslie or Veronica you can think of that family courts might get involved?
I do think things that I think for family courts seem basic, or the presumption, but if you can make a finding that the marriage exists, that there is a marriage, then it's going to be harder for the Department of Homeland Security to go behind that. If you can make a finding about abuse, and the details of the abuse, or you're going to order something in a protection order and you explain why, or explain, as we'll be talking later on, about, about extreme cruelty that you may have seen, can also be super helpful. So what I'm going to do now is I'm going to take you kind of through for me, it's a stroll through history. But it's really talking about kind of what Congress did and why, and how the battered spouse waiver that we're talking about today relates to and is different from, but is serving the same population as the VAWA self-petition. So they created two forms of relief for spouses of citizens and lawful permanent residents, spouses and children. The battered spouse waiver was created in 1990. These are cases, the big difference is the battered spouse waiver is always going to be a case where the abuser went and filed something with the Department of Homeland Security to get immigration papers for his spouse or his child, her or his. I'm gonna be talking from a gender perspective. I'm gonna be talking about victims as she and perpetrators as he. These are gender neutral statutes, but generally speaking, there are more victims that are women and more perpetrators that are men. That is not to say that he couldn't. It could be same-sex relationships. They could marriages, which are treated the same as heterosexual marriages. So, but the abuser will have had to file an immigration case for the battered spouse waiver. The parties would have actually appeared together at an interview that Veronica is going to be describing more later. And then when they were ready to give the green card to the spouse on that day, they were married less than 2 years. So that's the group that has this joint petition requirement that they're supposed to be in a marriage for 2 years and then petition to remove the conditions. The VAWA self-petition helps. There are a whole bunch of families. It's about actually over 70% of the time when an abuser could file papers for his wife, he doesn't. And so the VAWA self-petition was created for those cases where they're the same relationship, children and spouses of US citizens and lawful permanent residents, where the abuser never filed for the immigrant spouse or child. That's the big difference. Same immigration status, same relationships, but in one case the abuser filed, in the other case they didn't. Both forms of relief help spouses, former spouses, and spouses where the abuser was a bigamist and the victim didn't know. Both cases, the victim has to have been subject to battering or extreme cruelty. In both cases, the US citizen or lawful permanent resident is the person who's the perpetrator. And in both cases, they can include their non-citizen children who don't have lawful permanent residency already in the application, so that it can be an application on behalf of the spouse, the abused spouse, and child. And all of them result in a green card. And they're all people who would have had, both groups of these cases are cases where the immigration law on its face always had a green card essentially waiting there for the spouse or child, but they had no way to file before the battered spouse waiver or the VAWA self-petition were created. And so Congress created these to allow the victim to file the VAWA self-petition for the victim file their own case, the battered spouse waiver, to get the victim out of that 2-year trap, essentially, and to be able to leave the relationship without waiting 2 years, and to be able to leave it if they could prove battering or extreme cruelty. When you look at the legislative history, it has to be somebody that it provides the immigrant spouse who's in a bona fide marriage a way to escape beatings, insults, and fear. The law has acted, they recognized, Congress, that the law acted as a deterrent to foreign spouses coming forward and being willing to leave because deportation was something they were afraid of. It stops divorce proceedings from forcing, from a victim, like we were asking the questions in the beginning, victims feel like they have to stay and can't get divorced. This allows them to get divorced and allows them to escape. And the abuse they basically are, what Congress was trying to do is send a signal to abused spouses of US citizens and lawful permanent residents and children that there was a way out and that it was unconscionable to have people trapped the way they were in these 2-year relationships, which is why, and in the materials that you have for this webinar, for the first time, we pulled together every shred of legislative history that I could remember or find. And it's now all in links in all of the materials, so it's accessible to you to peruse at your leisure.
So remember that this, what we are talking about is for people who already have a green card, right? We are not talking about people who are applying to get a green card. So these people already went through the process, right? Like they already established that their marriage was valid in good faith. The only issue is that their marriage was less than 2 years old, and that is the reason why they have this condition on the green card. Right? And so one of these things, in order to qualify for the battered spouse waiver, we need to be able to show that the immigrant spouse, the one with the conditional residence, suffer battering or extreme cruelty during the marriage, right? And so you need the battering or extreme cruelty, and you need to show that you entered into the marriage in good faith and not for immigration purposes. Remember, this is to prevent marriage fraud, right? That is the idea. And so what happens is then with this waiver, you are no longer required to ask your abuser to jointly petition to remove the condition with you. And you don't have to wait to get your green card, right? So let's say the person got abused, has enough evidence, then she can actually file, and she doesn't have to wait for the green card to expire. She can actually file as long as she had enough evidence to be able to remove the condition on her own using one of these waivers.
So, and what's really important is the battered spouse, the battered immigrant spouse is still eligible for the battered spouse waiver if they're still married or if the marriage is terminated. And when somebody files for a battered spouse waiver, as opposed to a waiver of conditions based on divorce, for example, they get VAWA confidentiality protection, which basically precludes, it notifies the Department of Homeland Security that the spouse is a batterer, and it keeps the DHS from relying on the information provided by that perpetrator, that if he's trying to interfere or suspects she's filing, they can't rely on his information. And the other thing that's really, really important, and I know we have a lot of victim advocates on the call, so I'm going to try to explain this in non-immigration lawyer ease or whatever language, is that most immigration cases, the Department of Homeland Security gets to tell immigrants, you must produce this piece of paper and that piece of paper and this evidence and that evidence. And if you don't produce it, what they call primary evidence, then it's harder to win your case. And that was a big problem for battered women. And so when we wrote the Violence Against Women Act of VAWA in '94, the original bill, one of the first things we did was create the Violence Against Women Act, any credible evidence rules, which stops the Department of Homeland Security in battered spouse waiver cases, in VAWA self-petitioning cases, in U visa cases, in T visa cases, in work visas, for abused spouse cases, from ever saying you must produce this piece of evidence versus that, and allows the victim to prove their case any way they can safely do so. So that they can, and that those any credible evidence rules apply to battering or extreme cruelty and to good faith marriage in these battered spouse waiver cases. So when you compare, this is like a chart you can turn back to. As you can see in these cases, that the VAWA self-petition and the battered spouse waiver in terms of what you have to prove are very similar. But there are two elements of proof in the VAWA self-petition that you don't have in the battered spouse waiver cases, which is good moral character and residence with the abuser. So you can, the battered spouse waiver cases are actually easier to win theoretically than the self-petitioning cases in terms of what you have to prove. I say theoretically because the processes are very different. We're going to be talking a lot about that. Some people were asking if we're going to talk about some of the challenges in adjudicating these cases, and we absolutely will on this webinar. And on that, back to you, Veronica.
Yes, so what do we need to prove? Right, definitely for the battered spouse waiver. So one of these things obviously is that they need to be able to show that the marriage was legitimate, right? Like you really don't have to worry about the status of your abuser because you already have that conditional green card. So you already overcame that requirement, right? You already showed that he was a US citizen, and that's the reason why you have your conditional green card. So another thing too is that you need to be able that that marriage was entered into good faith. And how do you prove that?
Actually, Veronica, you can change your own slides if you'd like.
Oh, sorry. Okay. So one of the, so let's skip the good faith marriage then and talk about battery, right? Like what is it that we are able to show, right? Like how do you prove that you had been battered, that you had been abused? Obviously, there are different ways, right? And so let's just see how would you prove it, right? Like what type of crimes would you have to show that you had been abused?
You've got somebody saying a protective order, pictures of injuries.
Pictures of injuries, right? Like, you know, a police report if you have it, right? Do you have any medical records where you went to seek medical help because of an injury? You know, usually, right, broken bones, like he pushed her down the stairs, something like that, right? Or
there's also somebody suggesting a letter from a therapist.
A letter for the therapist, that is not a bad idea. One of the things where I would actually use a letter from the therapist would be to show extreme cruelty, right? Because it's actually more mental and you don't really have the battery happening, right? Like because one of the requirements that that CIS has with having to prove extreme mental cruelty is that they want to get information, they want testimony from someone who is a trained individual, right? A psychologist, a psychiatrist, someone who is going to explain what happens to this victim and why she has suffered extreme mental cruelty.
But what's interesting on that point is this is an area where the Violence Against Women Act of 1994 overruled the pre-1994 regulations. So if you look at the regulations today, it still says you have to get a therapist or some kind of, and that's not legally true anymore. It can be helpful, but it is not mandatory.
Leslie, I don't think I can move my slides.
Okay, I'll do it. So as to battering, there we go.
So here's the list, and this is not an exclusive list, right? Like here's a list of different battering crimes. And, you know, a lot of you wrote stuff on the chat, and so this is also more information. Another thing too that you can show for battery is the fact that, you know, maybe you are being held hostage, right? Forceful detention, any threats to result in physical injury, right? Rape, incest, if the victim is a minor, forced prostitution, right? Like any act that constitutes an act of violence would qualify for as a battery.
Right, and what I would do is I think about anything that would be criminal in your jurisdiction counts as battery. So stalking may not be violence per se, but it is a crime. Or threats to kill the violence may not have happened, but they're crimes. And so battering includes anything that's crime, violence plus anything else that's a crime. Is this me? No. So what types of actions by the perpetrator do you think would fall into the definition of extreme cruelty? Anybody? Threaten to call ICE and get them deported? Absolutely. Financial control, torture,
Calling her names, right?
isolation,
Threatening her to take the children away from her.
some forms of psychological abuse could. And now they're coming in. Keeping her
Withholding
in-
medication, right? Engaging in acts, like withholding the medication or forcing the person to engage in behavior like drinking alcohol or taking drugs, right? Like stuff that is going to be affecting someone mentally.
They've got strangulation, they've got sexual abuse, strangulation, and abusing would be battering.
Mhm.
Using a pet might be extreme cruelty because it's not to her. I mean, there's those, and it depends on, again, the crimes in, but these are a lot of good examples.
And one of these things that we are seeing more and more is the use of technology, right? Revenge porn, posting messages for everybody to hear or to see, accusing her of having STDs and making it public, right? Like just completely trying to sabotage the victim and really affecting her mental well-being.
Exactly. Veronica, I think you have one more.
Yes, so what do they look for as the adjudicators? What do they look at when it comes to proving extreme cruelty? Right, they are going to definitely be looking at the dynamics of the relationship. The client is going to be writing a declaration, hopefully with your help, right? Because you will know what the legal standard is. The clients don't know. And so you'll know what's important in terms of her telling her story. One of the things that is important too is if the person is receiving counseling, that is very important because the adjudicator is not a psychologist, right? But he is going to be relying on information from someone who has the expertise, right? Some mental health provider, some psychologist, a licensed caseworker, social worker who can say, right, like I had been seeing how she is, like how it's affecting her, right? Like maybe just a regular doctor saying she has lost weight, she doesn't eat because she is being abused by the spouse, their low self-esteem, right? Like suicide ideations, right? Like things that really affect people mentally. All of that is important. And that's why it's so important to work with the clients because many times they say, I didn't get an order of protection. I don't think I can get this condition removed. But there are so many other ways in which you can help your client really prepare a very good case to be able to show extreme cruelty.
And there's a question about an adjudication. I don't know. I've been up at the Vermont Service Center training them on this list of what they're looking like for an extreme cruelty. And some of you, those of you that are victim advocates might recognize that many of the things on this list often appear in a circle. They're using the power and control wheel as part of how they're looking for these patterns of extreme cruelty. And we've created a tool that I think will be helpful to you to kind of see that anything on the left-hand side is going to be battering. Anytime you have what's called in this world of psychology, and I know California has been one of the first states to pass a law like this where coercive control can be a grounds for a protection order. Anytime you have coercive control, you have extreme cruelty. So it's like, once you can show proof of coercive control, and I think Judge Collins, that's something that state court judges see all the time in domestic violence cases, then you have extreme cruelty. But then there are other forms of extreme cruelty that qualify as extreme cruelty, like using children as tools, or accusing people of infidelity, or some financial abuse, adultery with minor. There are ways to have extreme cruelty that might not be part of coercive control. So it goes beyond, but one of the things when we do these trainings is I want people to understand that if you have coercive control, you have extreme cruelty. And I think for training that Judge Collins and I did, the adjudicators in the Vermont, that's how we train them. So we're telling you the same thing. Veronica, you're on mute.
Yes, I'm sorry. One of these things too that the adjudicators look at is if your client was evaluated by a psychologist as part of a divorce, right? That information you can actually submit, because CIS is under no position to be evaluating a letter from someone who is not an expert, right? Like I couldn't really submit a letter saying, I think she suffers from extreme cruelty, right? Like I have no credentials to say that. But if I send my client to speak to someone who's a licensed social worker who can get and give the information, and different universities have clinics, psychological clinics where they do pro bono work. That's one of the things I use for my cases, right? Like just having my clients get those mental health services, and then I get this report where the psychologist is saying all of these things that my client has disclosed, right? Like that is great evidence to submit when your case is only based on extreme cruelty.
And you can also get the court order to say, the court finds there was extreme cruelty by these mechanisms of coercive controlling behavior. Because courts do that all the time. They find that. And so you can just make sure that they specifically state that in the court order.
So how would you prove extreme cruelty? Go ahead and you can type it.
Yeah.
Oh, it looks, Judge Collins, like somebody wanted you to say that again. Like what you'd have the court state in an order.
Yeah, so in the court order, the judge makes a finding. So just make sure the finding is really explicit. And you can say that this person suffered extreme cruelty by being a victim of these following acts, and then list the coercive controlling behavior, like they took away their immigration papers, they took away their financial access, they monitored their activities, and all of these coercive controlling behaviors equal extreme cruelty. So, list it all out, be very specific and describe each particular act and say and that's why the court find that this person was a victim of extreme cruelty, which you're going to be doing in an order of protection or in other orders too. So you can get them to do it, but just make sure they list it all out.
And we put it down in this slide, right? Like court orders of protection, right? Like your findings, as Judge Collins is saying, a finding in a divorce case, in a custody case, right? Like, and so you have that evidence and it is signed by a judge.
Okay. Oops. Where are we? Okay. So Judge Collins, go ahead.
Yeah, this is how and what types of cases can state court judges help document extreme cruelty. So what types of cases do you think that we'd see where that might come up? If you want to just chat in there. So I think almost every case, I mean, really, there are many cases that we hear that might not be the kind of case you think would come out that could be, such as, landlord tenant or things of that nature. But almost in every case, but certainly in orders of protection, criminal cases, juvenile or dependency or abuse and neglect, custody cases. You know, there's a lot of types of cases that come in the court system that the court can document what is extreme cruelty. And so you just have to make sure that when your judge makes your findings, that they say, I find that extreme cruelty existed here, and this is why there is. So are there any other examples that you can think of, Leslie and Veronica?
So I'll start. You know, one of the things that used to happen that I saw a lot of, and somebody, it came right up in the chat when we were talking about extreme cruelty, this immigration related abuse issue that you're threatening to get her deported and turn her in. And in fact, for years ago, like in the mid 80s, early 80s, judges in the District of Columbia started ordering the perpetrator they would make findings about the immigration related abuse. And then they would order the perpetrator not to contact not only DHS, but IRS, CPS about the victim, absent court order or absent kind of like a police emergency. And those were very effective. I enforced several of those by jailing the perpetrators for 6 months by criminal contempt for those kinds of things. So they can be, you can make the findings in that kind of context. Veronica?
And also, there are other instances in which you may want the judge to order that the abuser stop some type of behavior, right? Like, what else could you be like more specific, right? Like I was saying before at another day, that a judge ordered the abuser to stop throwing eggs at my client's car. Right, like every morning she came to get ready to go to work, and then there were eggs like all over her car, right? Like all of that stuff that you don't think a judge could actually order, you just need to ask the judge, right? And if the judge finds that it is relevant to make sure that the abuser stops that behavior, then that judge is definitely going to order that.
Right, and it's interesting. There's a question about
the judge.
Go ahead, Rosemary.
Oh, okay. Yeah, just have the judge say that in the order. Say the evidence showed that this person threw eggs at her car, which resulted in extreme cruelty to her because she was late for work. She had to clean her car, blah, 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 blah. And therefore I'm ordering it. So the more specifics you can put down about what the activity is and what that means, the better off you are. Leslie?
Right. And related to that, there's a question in the chat about no findings protection orders. And so, yes, you can do them by consent, but sometimes if you need to strengthen the evidence in your immigration case, you might want to go ahead and get findings or get them to agree to findings of some kind, or have a very detailed protection order that they then consent to, that you can then include as part of the protection order petition, that you could include with the order as part of the evidence in the immigration case.
That's a real problem for victims across the country, are these consent orders, because they often always are entered under the condition that there are no findings. I would urge you to not allow that to happen, to make sure those findings are there. Those orders don't do your clients really much good. And so even though that may be the practice, I know from other states that it is a big practice, but it's just going to have to stop, because you can still do a consent order if you can get the findings entered into. But if they'll do a consent order with no findings, then I would suggest you re-examine the practice of allowing that to happen on behalf of your clients.
So going,
we have a question here, right? USCIS will examine the evidence that marriage was entered into good faith with extra scrutiny when a divorce or annulment has taken place.
for voting.
Correct. True. Order of protection.
Okay, so we're seeing, Veronica, do you want to process this?
Yeah, so we are seeing 84% so far say true. And actually, one of the things that we were able to obtain with this fraud referral sheet that USCIS has, they specifically list divorce and new marriage dates are close, short time between entry into the country and marriage. So they are definitely going to be scrutinized in these cases, right? Like if you just got a divorce and then 2 weeks later you went and married the next person, they are going to be looking at this, absolutely. And they have it as part of a red flag to determine fraud in the marriage.
384 people on this thing.
All right, Rocio. And so we can, but basically the fraud list that she's talking about, we are adding to the materials list that we're providing you for this webinar, so you'll be able to take a look at it too. Oops, where are we? Somebody moved it a different place. There we go.
There
Okay.
we go.
Okay, so we are going to move on since the battered spouse waiver requires that the person show proof that she married the spouse in good faith. So one of the things that is important to remember is that the intent of trying to establish this relationship at the time of the marriage, right? So that is what you need to know. So what was their intent when they got married? And so, you know, you really don't need to say that you were in love, right? Like love is not a requirement to show that you entered into a good faith marriage. And the idea is, did they really intend to spend their life together? Right? Did they have the intention of continuing with this relationship? And so it is important to think too that you don't need to have children with your spouse to show that you had a good faith marriage, although it definitely helps, right? But there's no requirement that you have children with your spouse. And it is important to think too that you have to be able, right? Like if you think, if some of you are married and you're thinking about your own marriage, right? Like if I ask you, show me that you marry your spouse in good faith, right? Like what would you come up with? Well, you know, I'm on his life insurance. I'm the beneficiary of his life insurance, or he's on my health insurance. Things like that, right? Like we have a joint bank account. There's no requirement that you have X amount of money in the bank, right? Like, but just showing that you are able, that you have been living together and that you have commingled your assets and your debts, right? It's actually good to show, right? That you have debts together. Maybe you bought a house together, or you are paying for a vehicle that is under both your names, right? Like stuff that you would say, oh, of course I could actually show that I married my spouse in good faith, regardless of love and regardless of children.
So Veronica, I have a question that came up in the chat. For VAWA self-petitions, whether the marriage terminates by divorce or annulment doesn't affect the self-petition. Are there dangers to annulment here in these cases?
No, because in this case, you already got that green card, right? Like you already went over and proved that your marriage was entered into good faith. And so when you go to remove the condition using one of these waivers, you really don't need to worry about that. One of these things, because, you know, chances are, and let me ask Judge Collins, right? Like if you have someone who was married for 2 years or a little bit less than 2 years, and they come asking you to annul the marriage, like they have to show a basis for qualifying for the annulment, right? And what would you require of them, right? Like I had cases before where they wanted to get an annulment after having 2 children together, right? And the judge would be like, absolutely not, right? Like this is not the standard. So you definitely need to look at your annulment statute in your state. But I assume that Judge Collins wouldn't grant an annulment in a case like this with this fact pattern.
That's right. And if these things come in, where we see a lot of them come in are pro se, litigants that, you know, they may not have an attorney, and you'll see a spouse come in and want an annulment instead of a divorce. And then you find out that there are some real reasons for it. And the other spouse, the victim of spousal abuse, can often come in and say they're going to agree to it because they're told they have to, or they're being threatened or coerced into doing that. So just take a long, hard look at those things, because no, you're right. You don't do annulments under those circumstances. If somebody wants an annulment, then that's very suspicious. You know, usually the only annulments we do are if somebody actually was married to somebody else at the time they entered into this marriage. So you'll give an annulments, but annulments late in the marriage, that's suspicious. And so judges look at them very closely, and they should.
Right. And what's really important to note is we've seen cases through technical assistance of victims who agreed to annulments, and then the perpetrator went in and turned him in to the U.S. attorney for marriage fraud. So don't do it. If your client is, you know, for a battered immigrant to agree it, they're setting themselves up for a potential criminal prosecution for marriage fraud. And in these cases, and you do not want to do that. Back to you on this slide, Veronica.
Yeah, but before we move on, Paul posted on the chat, abusive spouses usually don't commingle assets, and that's actually very good, because you could say that in your client's personal declaration, right? Like, I have no idea if we have a bank account. I have no idea if we have a savings account, right? Like, I have nothing under my name. And that is part of, that is for you to show financial control. And so it goes both ways, right? Like, you can actually show by the lack of assets, commingling assets, that your client has no access because of the abuse. So that's important. I wanted to bring this up. And as Leslie said before, right, like now we have same-sex marriages are becoming more common now, and obviously abuse among these couples as well. And but they get treated exactly the same. It takes a little bit longer to be able to find evidence. I have had a couple of cases where maybe one of the US citizen actually wasn't out to his family. And when we went to the interview, the officer asked, you know, are these your parents, as the officer was looking at pictures, and he said, no, they are friends. My parents don't know that I'm gay. They think that my husband is my roommate. And you know, the officers are actually trained in these issues, at least in my local district office in Detroit. And they are compassionate and they understand, right? And they know they cannot have a different standard for same-sex couples, because, you know, we will be jumping to ask for a supervisor right there. But it is important to think that many times you are not going to have that evidence to show the relationship, and, you know, that everybody knows, and that the family supports the couple, because there may be other issues related to being same sex. And so that's something that should not prevent you from going forward, because as long as you have enough evidence to show, right, that the marriage was entered into good faith and that there was abuse in the relationship, you can go forward regardless of whether they are heterosexual.
So we're going to do another quick poll. Please check all that apply. What are the facts and evidence that could provide proof of good faith marriage? See the votes coming in. I'm going to speed this up a little bit because we want to continue moving. Be sure to have enough time to get to the challenges in these adjudications. Okay, a few more seconds. So what I'm seeing is children is coming in first, which is true. Residents with the abuser and love letters are coming in kind of second. And if you could show the poll to everybody, battering, extreme cruelty, or coercive control, almost none of you are picking. Actually, battering, extreme cruelty, and coercive control are absolutely evidence of good faith marriage. Because if you think about it, if you made up a fake marriage to somebody, are you going to beat them up? it doesn't mean, the better evidence you have of abuse also shows evidence that this is a real marriage. And so it's something to think about. So there's a list of things you can think about, different ways to prove good faith marriage. There's traditional evidence that, and the regulations and the policies on this are quite good, recognizing that battered immigrants may not have the same kind of traditional evidence. They might have more difficulty getting documents about finances and things like that. That's where those of us that are family lawyers can come in, because we can get the judge to order that some of that be turned over in a protection order case, or we can get it to discovery in the family court case, but that they can go forward in creative ways because of the any credible evidence rules, even if they can't put their hands on that evidence.
So let's talk about what types of cases would a state court judge document the existence of marriage? So put in any examples you can think of, but in an effort to speed this up, we're going to talk about it a little bit, but it can be in any regular case you might think of. Obviously, divorce, you document the existence of a marriage. In a custody case, in an order of protection, you can document it in any kind of paternity case. You can document the existence of a marriage, even though they may be denying the existence of the fatherhood. You can still document that they were married. But it can come up in odd courtrooms too, like in small claims court. Sometimes people sue for the return of a ring, and they'll say that was my grandmother's ring and I want it back. And so you can document in there too. Oh, well, you people were actually married, and this is what's happening. So you can use almost any case that your client may be in to document the existence of a marriage, if there was in fact a marriage. But what my question is to you, Veronica, is what about common law marriages?
Yes, so, and I know someone else had asked that before. So as long as common law is recognized in the state where your client lives, that is perfectly okay. And so we have a slide here. We have 7 states and the District of Columbia that recognize common law marriage. Right. And so, and many times you are going to hear your clients say, my husband, my wife, right? And then when you asked if there was a legal marriage, they said, no, we just live together. Right. And so we never really had a legal marriage. And so these are the states that that recognize it. And so it is important to think about that if you are trying to help someone in that jurisdiction. Someone's posted that Rhode Island is also a state with common law. So thank you for telling us that. We didn't have Rhode Island on our list.
Great to know. So what I'm going to very quickly talk about VAWA confidentiality. We have whole webinars on this, but the real important thing is that when you have a conditional 2-year green card, you can get lawful permanent residency by asking for 3 different kinds of waivers. And Veronica is going to go into that in a bit. But the difference is it's only the battered spouse waiver that gives you VAWA confidentiality protections, which means they can't rely on perpetrator provided information. All the information you submit to the case file is sealed. The perpetrator can't get it, can't discover it. It can't come out in a criminal or civil case. So it's really important to understand that there's a big difference between the battered spouse waiver and the other hardship waivers on that. And that what's really important is this is what we did a FOIA of USCIS, of DHS around battered spouse waivers. And they basically said they're telling adjudicators that and all the response in our FOIA is on the materials you have. So you can dig through it at your leisure. But they said they can't use squeal letters from the abuser against the family member. They can't use statements from the abuser against the victim. And that you can't use fruit of the poisonous tree. They can't take something and that he said and use it against her. So it's very powerful and a big important difference. VAWA confidentiality applies to all different kinds of cases, including these battered spouse waiver cases, and there's very limited exceptions. The main one I'll talk about here is that some people thought that judicial review meant any case of any judge in the country. That's not true. There's a case called Hawk out of California, federal courts, that DHS has adopted essentially that opinion in its policy, and the judicial review exception applies to a judicial review of the victim's immigration case.
And that's really important for your family courts because the good law is hard to find in immigration cases. And that's why this material is so very important, because the implications in family courts are often going to be that people will try to get discovery in a family court case that they are prohibited from getting. And so that's why it's important to know about VAWA confidentiality. It's important to know how that affects the rules of discovery. And it's important to know that if they start citing, the regulation that says judicial review, that judicial review does not apply to state court judges. And so it can't be turned over. So be very careful in your family courts that they don't go into discovery issues that they're not allowed to go into.
And one of the things we'll be distributing, and Rocio, hopefully you can make a note of this, Veronica and I and a number of New App staff did an article in a journal where there's a whole chapter on how to use VAWA confidentiality in family courts to protect against discovery. And we can send you a PDF of that whole article as part of the follow-up to these materials. So, and this is information, these are DHS's documents of the instructions to their adjudicators. So once a victim files a battered spouse waiver, and that is true, or for those of you that are practicing immigration law and that are on the call, if you're, let's say, going to an interview where both parties are there, she's not done a battered spouse waiver, she's trying to get her papers through the joint petition, let's say before she actually gets her conditional green card. If during an interview, well, actually, there could be an interview on battered spouse waivers too, there are, or on joint petitions, but whatever. If during the interview, DHS gets a hint of the fact that there might be domestic violence going on, they basically, and when somebody files a battered spouse waiver, they immediately flag the case for VAWA confidentiality, get a safe address, and enter it into the central index system the same way VAWA self-petitions are entered. So I wanted to, we did some social science research and field research in 2016, and we basically found about battered spouse waivers that there were high percentages of them where there was both battering and sexual assault, higher actually than even VAWA self-petitioning cases, and that the number of battered spouse waiver cases that were based solely on extreme cruelty was half the number as VAWA self-petitions. We also found that, one of the things we found on this research and some research we did in 2017 is that where perpetrators were US citizens, which is the case in all of these cases, the likelihood that the victim would stay with the abuser longer and kind of be trapped in that relationship because of the immigration related threats was much higher. We saw a 391% drop in people being willing to file VAWA self-petitions because of the coercive control over the perpetrator. And this shows you kind of some of the abuse that victims who are stuck in these relationships are experiencing. And that, but despite that, battered spouse waiver applicants, even though many of them stayed with their abusers while they were going through the process of filing, were calling police, seeking protection orders and divorce at fairly high rates. This is what we see in terms of battered spouse waiver justice system involvement. And then when we looked at how adjudication times differed, and this goes back to I think one of the first questions here in terms of some of the challenges here, we saw things like the adjudication times were taking at least a year longer than the VAWA self-petitions. They were, and also many adjudicators, many of the VAWA, so the VAWA self-petitions don't have an interview process generally until the victim gets, in some cases where the victim is getting lawful permanent residency, but these cases were getting referred for interviews at quite high rates, and you see dramatically different rates of referring for interviews between the California Service Center and the Vermont Service Center. For those of you that haven't done battered spouse waivers before, what's important to understand here is the Vermont Service Center people that are looking at the battered spouse waivers are not the VAWA unit. They're not the specially trained unit in Vermont that does the self-petitions. They're just regular other adjudicators like it is happening elsewhere. So the VAWA unit adjudicators have intensive training that the adjudicators at the local offices do not. And as a result, we found, and that intensive training covers domestic violence, dynamics, types and recognition, requirements for immigrant relationships, confidentiality, credible evidence rules, and that they get, this is kind of an outline of the kind of training they get on any credible evidence rules in battered spouse waiver and child waiver cases. This is what's supposed to happen. This is what the VAWA unit gets itself, but that the amount of training, we are actually never able to find out through our FOIA how much training that we're actually getting that were in terms of the local adjudicators. But these are guidelines that DHS released as part of the FOIA about how they're supposed to be doing their jobs. And we want you to have these so that if you have to go into an interview or you're preparing a battered spouse waiver for your client, you have the information. You should know what they're supposed to be doing, because as we found in our research, that the people doing the interviews often were not following the rules they're supposed to. They were minimizing the abuse 46% of the time, asking victims why they were staying 51% of the time, questioning the validity of marriage when the user had been arrested for domestic violence 30% of the time. I mean, really, and it's really important that you be aware that you're not going before an adjudicator who's been trained when you're doing these battered spouse waiver cases, because you've got to be prepared to defend your client and be prepared from a trauma-informed perspective to prepare your client for how you're going to respond to these kinds of questions, which in my view, you shouldn't be getting otherwise. Veronica, did you want to comment on this?
Yeah, so someone posted in the chat that USCIS said in a public call that the adjudicators only get 6 hours of training, and believe me, it shows, right? Like, it is not Vermont. They, as Leslie said, they do not receive extensive training, and it is difficult. If for some of you who may be doing this type of work, I don't know if your experience has been that you receive a lot of requests for evidence, mostly for information that you already submitted with your initial application, right? Like, which is pretty frustrating. I have gotten requests for evidence asking me for more, even though my client maybe had 2 children with the abuser. You know, they want to know more. They want to know why is it that there is very little money in the bank account. They want to know why is it that they file their taxes separately if they are married. You know, like different things like that that definitely could be resolved with a little bit of training. But then, you know, my experience has been too that for some of my clients, they don't even want an interview. They just adjudicate it on the papers, which is great, because then that is definitely going to help my client so she doesn't get re-victimized at a different interview.
Right, so that, you know, they're not, we also see violations of any credible evidence rules. What is supposed to happen is this is the policy. People have been subjected to, and the policy says they need to understand that people have been subjected to treatment, you know, abuse, may have difficulty discussing their life experiences, and that they're not supposed to try to force them to relive abusive episodes that are not necessary for the adjudication. So this is what it should look like, but I know that there are challenges that people are encountering, and I see there's lots in the chat box that we will respond to. Veronica?
So what would you do if you have more than one choice for your client, right? So you are looking at a battered spouse waiver based on battery or extreme cruelty, you are looking at maybe your client already got a divorce. So do you just check the divorce box? So what are your choices and why would you pick one over the other? So here you have the copy of the I-751 that has the different options. And so one of the things, right, like that is important to think, like it's timing, right? Because you have to file jointly 90 days prior to the green card expiring, the conditional green card expiring, right? As soon as the person files, like in a marriage where there is no abuse and they are going to be filing their joint petition, they file it together, they sign it, and then when they receive a notice, now with COVID, they are given 24 months of an extension of a green card. And so with that paper, the clients are able to continue to work and travel if they need to, right? So for that, they are extending it to 24 months. Another thing too is that if you don't file it, and at the interview, when they go for the initial interview where the client is getting the conditional green card, they are given, at least in my jurisdiction, we are receiving a piece of paper saying you are required to file a joint petition after, right? Like 90 days prior to your 2-year anniversary of your green card. And if you don't do it, you are going to become deportable, right? And so they are having our clients sign the documentation saying they are aware, so they don't say, nobody told me that I needed to remove the condition 2 years later. So it is important for them to make sure that they know, right? Like I usually, when I finish a case, I send them a closing letter explaining everything to them, like you must remember, right? I'm not going to send you a letter to remind you, like this is your notice that you have to file to remove the condition, and you need to tell them the consequences of not doing so. And so when the marriage, so in these cases, right, like you continue to show more evidence. If it's a joint petition where the husband and wife are both signing, then you need to sign and send it. If you are divorced already, you don't have to wait for the 2 years until your conditional green card expires. You can actually file it immediately. And also, you may be going to an interview. I haven't had, and that may change jurisdiction to jurisdiction. When my clients who are in a viable marriage file, we do not get an interview. We just get the green card without the condition mailed to us. So that is actually good, because we have definitely paper the application to make sure that there are no issues regarding good faith marriage and the viability of the marriage. So is an immigrant spouse able to file on multiple grounds?
True or false? We have a poll? I don't think so. Oh, here it is. Okay. True or false? And thank you guys all for participating in these polls. This is great. Veronica?
Okay, so most of you have said true, right? And so, and there are questions as to why would you want to do on multiple grounds. And so I'm going to give it to, I think, Leslie, to talk about what the benefits are of checking one over the other.
Yeah, sure. So basically, and the difference is, so the multiple grounds are extreme hardship, divorce, and battered spouse waiver. So the simplest way to think about this is there's 2 reasons why battered spouse waiver, if you're working with a victim, is always better, in my view. Okay, and Veronica, you can correct me if I'm wrong. But One is VAWA confidentiality protection, and VAWA confidentiality protection lasts forever. So unless her case is denied on the merits, they will always know he's a perpetrator. They can't give him information contained in the file. And that's really important considering how active perpetrators are in trying to get people deported. That's number one. Number two is there are public benefits so there are deeming rules, which I'm probably skipping everywhere, but we'll just do that. There are deeming rules that basically say that that to get access to public benefits for victims, if the husband has given her a green card, has filed one of these cases, whether it's conditional or battered, if she files the battered spouse waiver, under benefits law, the benefits agencies essentially pretend that she has full access to his income and resources for purposes of qualifying for benefits. If she files for a waiver of conditions through divorce or through extreme hardship, for the rest of her life, until the affidavit of support ends, they're going to consider his income or resources if she needs benefits. If she files a battered spouse waiver, she qualifies for the VAWA exemptions from deeming, which will give her access to benefits, and they will not pretend that she has access to his income and resources. So it's a huge difference in terms of the outcome if you go the battered spouse waiver route versus the divorce route. Veronica, what if divorce proceedings are initiated, but the divorce is not final before the expiration date of the conditional residence?
So if she has enough to show battery or extreme cruelty, that is the box I would actually check, right? Because they want the divorce to be final. And so, in the personal declaration that your client is submitting, you could say, right, like we have already initiated, and then you can submit like the initial pleadings, the complaint for divorce, information to show that you are, in the process of getting a divorce. You may actually get a request for evidence once the divorce is finalized, because they are going to want to see a decree of divorce. And hopefully you do have enough evidence to do it based on battery or extreme cruelty.
So Judge Collins, one of the questions I have for you has to do with, if people are coming in before you for these divorces and somebody's trying to speed up the process, or, what kinds of things, if you're doing a pro se divorce, what are your options if you're concerned that somebody's trying to get a divorce to cut somebody else off from immigration relief? How do you think about it as a judge?
Well, I really think it's important to ask some questions, and it's hard to do when you have a prove-up call, which I've had. You'll have a lot of cases and you have little time to go through them, but you just have to take the time that these cases need, and make sure that you have qualified interpreters in your court proceedings, because sometimes English may not be the first language or may not be even close to fluent for the parties before you. So make sure you have qualified interpreters. Don't have a friend of the family. Don't have a relative of the batterer there. Make sure you have qualified interpreters. Get a continuance if you need to for the qualified interpreters. Have materials in the courtroom available for how people can seek legal aid if they are a victim of domestic violence, because you can often send them to a legal aid provider where they may not have the funds to hire an attorney, but there are legal aid clinics that can do that. And also, please make sure you tell your judges not to ask about status in the courtrooms. You don't want to ask that question. It puts victims in a real bind and opens up some other issues. And if your victim doesn't understand or answers it incorrectly, it can be used against them. So never ask about status in the courts.
It also can intimidate people, because one of the things, again, some of the social science research we've done shows is that courts that provide qualified interpreters and courts that are signing SIJS or findings and courts that are signing U visas and T visa certifications, immigrant victims are much more likely to go to those courts to seek justice in all kinds of family court matters and even criminal court matters. So it really does help with access to justice. And so, Judge, if you, let's say, would you, like, if you've got somebody before you on a prove up and maybe the court didn't notify you that there needs to be an interpreter for this case, could you continue it? And what kind of advisals might you be able to give a victim to get them to the right places if you're finding somebody who's pro se?
Right, you can continue it and you should, because it's really important. I've had a lot of cases where people be coming in and giving up a lot of rights, including rights to pensions, rights to all sorts of financial relief. And they often don't know that they can. They often are so anxious to get out of a marriage, they're willing to do it. So you need to make sure that they understand what they're doing. They can't do that without a qualified interpreter. And I saw somebody put up in the chat that most courts have interpreters. You'll be shocked to find out how many courts do not have qualified interpreters. So make sure that you check that that interpreter is qualified, and then continue a case to make sure that people get access to justice that they deserve under the law.
I think one of the issues, though, that, maybe for another webinar is the fact that you may be seeing a lot of prove-ups of people who are unrepresented. And so you have two parties there and you're not able to understand them. You don't know the dynamics, right? Like you don't know if she's being coerced into saying, yes, this property division is okay or this custody is okay, right? And so those are the cases that I find very difficult because people.
Well, you can always ask questions too, and your court they should ask questions. Have you talked about pension benefits? Have you done this? Have you done that? And you should really kind of assume that the person who's agreeing is giving up a lot of their rights and their what they are legally allowed to get under the law, probably are doing it without knowing what their rights are. And oftentimes an abuser will have an attorney and the immigrant victim will not understand that attorney does not represent both of them. And so they will think that the attorney in the courtroom is their attorney, even though that attorney is not. So it's really important that you make sure that the rights of the immigrant spouse victim are protected.
And so going back to what I was talking about a little bit before, when you compare the battered spouse waiver with the divorce and hardship waivers, when you apply for benefits, many benefits, the big ones, TANF, food stamps, SSI, subsidized healthcare, have 5-year bars to benefits in most states. That's the federal law. And there are some states that provide special access to benefits for battered immigrants. And so if somebody goes the divorce or hardship waiver, as opposed to the battered spouse waiver, during that 5-year bar, they can't get the state funded benefits for battered immigrants because they don't qualify as a battered immigrant because they didn't get the proof in the immigration case that they're a battered immigrant. And what's also good about the battered spouse waiver is once they win, they are permanently exempted from deeming and they never have to do anything else. In VAWA self-petitioning cases or in other cases, that's where judges issuing protection orders can be really important, because a victim who, let's say, is pursuing a VAWA self-petition gets a 1-year exemption from deeming, but then they need to either get the self-petition approved or have Judge Collins issue them a protection order, and then they're permanently exempted from deeming. So it can come either from the immigration world or from the family world. So these are the policies. Again, if USCIS finds out during an interview on a joint petition that somebody's been battered, this is what they're supposed to do. They're supposed to inform the survivor. They're supposed to separate the parties and not do this in front of the batterer, obviously. And they're supposed to inform her that she can withdraw the joint filing and file for the battered spouse waiver. They ask for a written statement of withdrawal, and she gets acknowledgement. They ask her to identify a safe address, and then they shift the standard to the any credible evidence standard. So the standard of proof gets better and easier if they pursue the battered spouse waiver than when they pursue the joint petition or the divorce or the hardship waiver. So what if the condition, so Veronica, if we've been talking a lot about divorce, but can somebody file a battered spouse waiver if they're still living with their abuser and still married?
Yes, if he has actually said that he's not going to file the joint petition, right? Like in your example before, you know, if he's already there during the interview to do the removal of the petition and they are together, I don't know what the advantage would be to disclose that you are a victim unless the adjudicator is planning to deny the removal of the condition. But yeah, if the abuser is saying, I'm not going with you, I'm not going to that interview, right? And then the 2 years are coming up, then she should definitely be able to file it without him using the battered spouse waiver.
So under what circumstances, Veronica, might somebody want to file a self-petition if they already have conditional status?
If they are not able to show that they were battered or that they suffered extreme cruelty, that may be a good idea. It may also be that they forgot to file to remove the joint, you know, to remove the condition using the I-751. And now they are worried that they may actually be put in removal proceedings. And so that may not be a bad idea to think about a VAWA self-petition. One of the things that is important to remember, though, is that for the VAWA self-petition, you also need to show that you are a person of good moral character. So you need to make sure that your client really is going to be able to meet that requirement.
Judge Collins, anything you want to add to the judges or family lawyers as we come to the close of this webinar?
Well, always ask the judge to put things in the order that you think are understood. So, you know, ask the judge to put in that, you know, you find that they've proved the existence of a good faith marriage, that you find that they have proved the evidence of battery, and specify exactly what the facts were that show the battery or the extreme cruelty. You know, put in all the information that you do. And when you're doing your hearing, set out a checklist at the beginning of everything you want the court to put in and make sure you put in that evidence. So when the judge says, well, I don't know if there's evidence of that, and you can go back to it. So just make sure you prove everything you need to, and then make sure it's all explicitly set forth in the order. You can always do an additional page for the order. If the judge likes to do their own order, just say, Judge, I have a statement here of facts that were found at this hearing, and you can always add that to it, or ask the judge if you can prepare the order so you can make sure you put everything in there. That was actually proven up at the hearing.
So we're coming to the close of this webinar. What we'd like to do now, and we know there's some questions we might not have gotten to. We will review them carefully and get a Q&A back to everyone probably after the first of the year. But we wanted to invite you to tell you about several kind of exciting possibilities we have to continue these discussions, where we run some communities of practice where people can learn from each other. Veronica, you want to talk about the family law one?
Yes, so every month we get together with family law practitioners across the country to address different issues that their clients may be facing, their immigrant clients may be facing. And so it is a good opportunity for people to brainstorm, right? Like basically do case rounds and try to discuss different strategies for cases. We usually have a judge we have different topics. And so it is important because it is a very good group and we learn from each other, right? Like, oh, this doesn't happen in Arizona, but this happens like that in New Jersey, right? And so it's actually very good to be able to have this conversation every month with the attorneys and discuss these issues that affect the clients.
And I know we have a lot of victim advocates on this call, and we have a similar community of practice where victim advocates get together for learning from each other and for ongoing continuing education and all kinds of things like that. Those meet every other month. And if you want to join our community of practice, here's the link, and we'll be sending you these as well. And then I'm going to have Judge Collins tell you about our newest community of practice for judges.
So we have a national judicial network that does a lot of what was talked about with these other outreach groups. The judges come together and talk about, issues of law that they may be seeing, and then you can give resources. You can talk about where you can find seminars and webinars. So it's a great network of judges in a confidential setting where you can talk about areas of law that you find interesting or intriguing, or get some assistance from other judges in finding out the good research on it. So if you are a judicial officer, please join the National Judicial Network. And if you know a judicial officer, please make sure you forward them this information so they can join and get access to this incredible resource.
And the National Judicial Network focuses on issues around immigration and the family courts, immigrant survivors and immigrant kids, also trafficking victims, and all of the relief that's available for immigrant survivors is what we focus on in the family law and the advocate community practice. So my last slide is basically a link to where you can get the materials for this webinar and the kinds of materials we have available. I've mentioned you got the legislative history, the response from our FOIA, training materials on the battered spouse waiver, research on battered spouse waivers, and you can always call us for technical assistance when you have cases you're working on at these numbers and these contact information. And you can subscribe to our newsletter, get breaking news on what's happening with immigrant survivors and things that are important to them. And we have a library of materials available to you. And so thank you for staying just a few minutes longer. I really appreciate your participation today. I want to thank NCJFCJ for sponsoring this, Rocio for all the work you've been doing in the chat, and my co-presenters, Judge Collins and Professor Thronson, for the great information you shared today. Thank you, everybody, very much.
Thank you.
Thank you.
Have a good Thanksgiving.
Oh, don't forget to do the evaluations. Let us know how this went, and we'll be getting back to you with a Q&A on this as well. Thank you.
Thank you.